study or a story. Well, good morning, everybody. Welcome to this webinar. We will get started because I know that there'll be quite a few attendees and quite a lot of interest. We want to cover as much ground as we possibly can today. Firstly, thank you all for taking the time to join in. And a few introductions to begin with. My name is Chris Hynes. I'm a strata advisor with Hynes Legal here in Brisbane. I was formerly the Commissioner for Body Corporate Community Management in Queensland. And as I say, I'm now with Hynes Legal as a strata advisor. Joining me today is Frank Higginson. Frank is a partner at Hynes Legal. Hi, Frank.
Hi, Chris.
And also joining with us today, Rob Honeycombe. Rob is Managing Director of Bees Nees Realty in Brisbane and a past chair of the Real Estate Institute of Queensland.
G'day,
hey,
Rob. G'day.
We're doing this webinar today in conjunction with LookUpStrata. Thanks, Nikki and Liza, for getting this all together, as always. Just a couple of very brief housekeeping rules. You are perfectly entitled and able to ask a question via the chat facility. Please try and keep it relatively on topic. We'll try and get to as many of those questions as we possibly can today, and we'll try and answer them live as opposed to a written answer. Just be aware that when you do pose a question, everybody who's participating today will be able to see it. So just bear that in mind before you ask. We are scheduled to finish up at 11 today. So again, also bear that in mind. We'll try and keep things on time as much as we can. With that, we might kick into it. So the purpose today was to talk about issues relating to residential tenancies in particular, and also any overlaps with strata in Queensland. So the prompt for this is that last night, Queensland's Parliament passed a bill to give effect to some emergency measures related to COVID. And that bill included provisions for residential tenancies. I guess, Frank and Rob, the first thing to note is that we don't necessarily have all of the formal detail at the moment, do we?
No. I mean, at least we've seen the regulations. So I suppose from a legal perspective, they've started with a very wide-ranging act, which gives the minister, I suppose, some regulation-making power personally to address other things that pop up over time. But we have seen the bill, the regulation in relation to rental, which has been probably very heavily in the media for the last 2 or 3 weeks. So I've spent no time at all reading any of the stuff that's been on the front page of the Courier Mail because it has been changing relatively frequently. And for me, the first time I've actually seen the detail was when I sat down at sort of 5:30 this morning to start to read it based on what was passed last night. So we do have some, but not all. But enough to actually, I think, give people some guidance today.
It was interesting, Chris, that the Minister now has the power to make guidelines that are not inconsistent with these regulations. And I gather that, well, he said at his press conference that he's set up a committee to help him with that. And that includes representatives from Tenants Union and Queensland Shelter, the RTA itself, and the REIQ representing property managers and property owners. So hopefully as those guidelines come out, we don't see too many surprises compared with what has actually been talked about today.
But I think it's important that you make that point, Rob, because the potential for surprise is there. And I think it's also the other point to make is that this is not a normal process of government. The way in which things would normally work is that there would be a lengthy period of consultation, there would be a bill introduced, it would go off and be examined by a committee, come back, debated, and there'd be a substantial lead-in time. You don't usually find things happening this way, where Parliament passes a bill in a day and then it's over to the Minister to set the detail of that thereafter. Doesn't usually happen that way, but we are living in these surreal times, and this is how things are happening at the moment. Jens, we might kick off. I might, Rob, hand over to you as a real estate agent, sort of out there every day at the coalface, interacting with tenants and with landlords. What sort of stories and situations are you encountering at the moment?
Well, the initial response after the Prime Minister's announcement back in March 22nd, I think, when he first talked about the moratorium on evictions, the initial response came from landlords saying, hey, look, if my tenant has a problem, please be sure to talk to us because we're happy to help out. So, and then very quickly, hopefully not surprisingly, from tenants saying, oh, look, I understand my landlord's got some tough times happening as well. So you'd have to say the initial response has been one of mutual understanding of each party's situation. So despite what we'd love to, the media would love to talk about, or the conflict, for the most part, people have been getting on with the negotiations, recognising that there's two sides to this, that landlords aren't all Scrooge McDuck lying back on a vault full of cash, that they do have their own issues, and trying to find some mutual agreements. So we don't have a lot of tenants trying it on. We've had a couple, of course, as you'd expect, but for the most part, people aren't really asking for assistance if they don't need it.
I think, no, again, I think another important point, because one of the key things that's emerged from, you mentioned there, the Prime Minister's statement and subsequent statements from the Premier and the Housing Minister, is this need for parties to enter into discussions, to communicate, to talk about what is and is not possible under the circumstances. It's a point that Frank and I make all the time when we talk about body corporate issues, that the sooner you get on the front foot and start talking about the issue, the better it is for everyone, and the better your chances are of coming to a settled position. That's right, isn't it, Frank?
Absolutely. And front foot is not the typical scorched earth legal position of sue everyone. You know, like this is one where communication is just so important. And letting people know what's going on at both sides of the coin is even more so. So, and even, I suppose, in terms of what they've done with this regulation, I can see that sort of built into it as much as it might not necessarily be express. I think there's some best practice stuff in terms of what they have produced that we'll be talking about today that I think everyone sort of needs to build into their processes for the time being. Oh.
I think Rob just had a brief technical moment, but he's coming back, which is good. Welcome to this surreal time, I suppose. While that's happening, let's just turn our mind to what has been announced. So, as I say, bill was passed. In this case, quite unusually for these circumstances, the Housing Minister tabled last night a draft regulation in Parliament. And that is now available. If you want to go to the Parliament website, you can access that yourself. You just need to search for that. That's probably your best option. That regulation sets out what it is that these provisions are going to look at. It's split up into a variety of divisions, talking about rent, talking about termination, and a few other things as well. Frank, we might turn our mind to probably the most kind of burning part of all of that, which is the issue about hardship and about payment of rent therein. So the hardship definition is pretty specific, isn't it?
It is. And so, yeah, so the very start of this regulation creates a definition of what is excessive hardship. So for me, probably the way to visualise it is that for tenants to take advantage, to tenants to have available to them the protection by this regulation in relation to payment of rent, they need to be suffering excessive hardship. And unless that is actually the position, then they can't get through the gate, and therefore they've still got the same obligations they do as tenants today with respect to their rents and everything else. So, and the regulation itself, and I think probably, Chris, we might follow up on an email or a link. We'll get Nikki to send it out after this as well. Yep. Effectively, to take the benefit or to get the benefit of excessive hardship, you or someone in your care has got to suffer from COVID-19. You've got to be subject to a quarantine direction. So this is talking about tenants. Their place of employment is closed, or their place of employment is restricted because of a public health direction. So again, take for example, someone working at the casino, someone working at a pub. Clearly those have been closed as a direct result of those health directions.
Someone working for Virgin, Frank, yep.
Yeah, absolutely. And the other one's person self-isolating because they're vulnerable. So vulnerable has actually been defined in the regulation. So vulnerable is someone over 70, full stop, someone over 65, who I think has health conditions or morbidity, which was a word that I actually had to Google. So there's the thing I've learned today. And that really means, I think, as best I can tell, sort of reaction exposure to viruses or poor reaction to viruses.
Basically, reduced immunity,
Yeah.
I think, Frank, yeah.
Okay, or someone of Aboriginal or Torres Strait Islander descent who's above 50 with those same health conditions or morbidity issues. So those are the people. So the first step is you need to be in one of those categories. And if you're not in one of those categories, then the protection in the regulation is not going to apply to you. Part two of that is then that person needs to have suffered a loss of income of 25% or more, and that is net income. So the net weekly income, so what you would otherwise have been banking. Or the rent payable by that person is more than 30% of the person's income. So I suppose for me, those things are financial, very strict elements that people are be able to prove or they won't. And I think if someone is going to make an application for relief in relation to COVID, then producing that sort of information that actually proves those things is going to be a reasonable request handled the right way.
Yeah, look, I think that's really important. This is not a blanket provision which says that now that everybody is in the midst of a pandemic, there is an automatic ability for you to not pay rent or not pay as much rent. That's not the case at all. And there's been a bit of misconception, I think it's fair to say, Frank, about this idea that, oh, this means we just don't pay rent at all. No, if you qualify under one of these defined criteria, or a couple of these, you have to qualify, first of all, under the criteria, and then second of all, there's the financial aspect. So there's two arms to it. You need to qualify under both. Assuming that you do, then you are entitled, as Frank said, to benefit from what is being offered here under law. So that's really important to clarify that nowhere in this reg does it say that automatically anybody who is a tenant can stop paying rent. That's not what this says at all.
No, nothing in there at all. And I suppose if so those definitions I was talking before about 25% of income, or you're paying more than 30% of your income as rent, they've expanded that also to include where there's more than one tenant or resident under the residential tenancy agreement. And I think that's an important thing there. They've got to be signed on to the agreement itself.
Yep.
So the typical, which is what some of our younger lawyers at work still do, one person's on the lease and then they effectively sublet bedrooms to other people. Won't necessarily include those subtenants, would be my take.
Although, Frank, it does go on to say if there is more than one tenant or resident under the agreement, so that kicks into your point, then those financial criteria are taken to mean that if there has been a 25% or more reduction in the combined total income of all the tenants and residents. So the way the legislation is framed, it's firstly framed on one tenant, but if there's more than one tenant, then it's a combined income.
Yep. So that is probably the very key thing, is that you've got to be able to jump through those hoops to be able to take advantage of the protections provided by this regulation. So
we actually have a question that goes to that point, and I won't use names in this. I'll just reframe paraphrase questions as they come in. Foreign students on visa, does the new regulation protect students on visa as tenants? Well, so long as they're tenants and they qualify under the criteria Frank and I have just outlined, yes, they would. Frank?
Yep, agree.
Simply because they're on a visa does not change that. We're talking about tenants. We're not talking about where the person is from. We're talking about the fact that they are a tenant. Looks like, Rob, you may be back with us.
I am, Chris. Can you hear me?
Fantastic. Okay? Can hear you. Yes. Can't see you, but can hear you.
Right. Mate, we've just spoken about what excessive hardship is and sort of coming towards the end of that. And I suppose for me as a lawyer, this is a tiny bit scary in terms of trying to talk in detail about regulations and laws that I saw for the first time a couple of hours ago. There's another question there about if sublet people aren't stated on the lease, does that impact the ruling? And it comes down to the literal wording of the regulation. However, if there is more than one tenant or resident under the residential tenancy agreement, and I suppose actually, Chris, or room in accommodation agreement, because this regulation applies to residential tenancies and room in accommodations. So that's like effectively, I suppose, the students sharing a room in some sort of university housing. So I suppose if you apply that respectively, tenant under a residential tenancy agreement or resident under a room in accommodation agreement. So probably my first glance at that is you've got to be named on the lease, would be my take.
That would be my take as well, Frank. And there's been a couple of questions about that. I can see that I think it's fair to say that, yeah, it says if there is more than one tenant or resident under the residential tenancy agreement. So there it is. There's the agreement that you've entered into, and it should name everybody on there.
And if it doesn't, then probably the discount, the threshold criteria only apply to the people that are named as tenants, would be my take on it.
Rob, what would you think?
Yeah, there is a reference to household somewhere, but I think that may be a bit further on. We're talking about entry requirements and vulnerable people. So that goes further than just those named in the tenancy agreement, I think.
Yep.
Yep. Okay, that could work. Yeah, that's a really good point. Actually, I hadn't even thought of that. And this is it. I think what you will find is that more and more this goes on, the more and more questions and uncertainties of that type will come up. That's just the nature of legislation. Has to be the case.
Yep.
The moratorium.
We'll just roll through the actual regulation, I suppose. Not quite line by line, but section by section, won't we?
Yeah, and things I suppose, and try and respond to as many questions as we can. There's a few. I mentioned at the start that Frank and I are from a law firm that focuses on body corporate issues. It's important to, I think, remember at this point that if you're a tenant, you have rights and responsibilities under body corporate legislation. And that's a point that sometimes people don't always remember or realise. So if you're a tenant, you have the ability to ask the body corporate to do certain things. For example, repair common property and enforce bylaws. Equally though, the body corporate has the obligation to ask you as a tenant to maintain your apartment and also comply with bylaws. Rob and Frank, sometimes that's a point that I think tenants, landlords and agents not always 100% sort of remembering, is it?
I think it's part of the problem around training, Chris. As you know full well from your past role, a lot of real estate agents don't get training in how a body corp works. A lot of them find it very overwhelming and confusing. So we know that a lot of tenants don't get given a copy of their bylaws, even though they're required to be. They're not informed on what their obligations are. So there's a real lack of information there.
So we might, if time permits today, we might get to a couple of specific residential tenancies, body corporate issues, because there are actually a few that emerge from these new laws, which might pose a few challenges for not just tenants and landlords, but also for body corporate managers and caretakers. But we might go through a few more of the specific provisions. Frank or Rob, where do you want to go to next?
Oh, mate, moratorium on evictions is very simple. You can't evict someone who's suffering excessive hardship. Probably until 31 December, I think, is when I was looking at the Act, sort of effectively defines the COVID emergency period as from the 19th of March through to 31 December this year. So while this regulation stays in force, if someone's suffering excessive hardship, you simply cannot kick them out for failure to pay rent because of that excessive hardship. They're still, the way I read this, they're still obliged to honour the rest of their obligations under the tenancy agreement. They can't go and break it in 1,000 other ways, and those rights to terminate are still there for those reasons. But just the simple failure to pay rent is not going to be one of those if they're suffering excessive hardship, which I think was one of the real big things from a REIQ perspective, wasn't it, Rob?
Yeah, it certainly was. I know that we've then had a range of owners saying, all right, well, their lease expires in August, so how about we just don't renew the lease? Well, the Act or the regulations go a step further and actually require that we extend all tenancies through to September 30 for those tenants impacted by excessive hardship. So you can't just say, all right, your lease is up, there's your eviction.
Yes.
You have actually got to extend that lease on the same terms through to September 30 as a minimum.
Yes. Yep, and that's exactly the next section. And I think probably, I know Chris has spent some time doing the reading speeches and those sorts of things. Clearly, this is very much a, you call it a pro-tenant piece of legislation. So it's just important to be aware of that. So, and I suppose the policy intent behind that is not having a whole lot of people that can't pay rent out on the streets. So right, wrong or indifferent, that's the way it is.
I think the part of that, Frank, though, that gets missed in all this is that the vast majority of landlords know that if they do put their tenant out in the street, then they're going to have a vacant property or a greater chance of it. We know the vacancy rate's increasing. There's been a lot of short stay property added to the long-term tenancy pool as well. So I know the legislation's got to cover these situations, but clearly there's a big misunderstanding that landlords and their agents want to have churn in their properties. They absolutely don't. And I know many of the listeners will agree that, you know, everyone's working to keep tenants in place. If they're a good tenant, the landlord wants to keep them.
There's motivations for all the parties, isn't there, Rob? I mean, you know, for whether you are a tenant or an owner or a real estate agent, there are motivations for you to communicate, negotiate, and work out a solution that's to everybody's benefit. Because at some point, hopefully, all of this will be over. Life will return to normal. God knows when that is, but hopefully that actually happens sometime soon. You have to, I think, really important to remember, you have to still be able to interact and get along with each other to a certain extent afterwards. So there's this period now where everything is different and changed, and it's challenging. I think we all accept that. But then there comes a period where we're back to normal, and you still have to have a relationship, for example, with your real estate agent. You still have to have a relationship with your landlord. You still need to maintain that, and it still needs to be ongoing. You need to do some work now to ensure it keeps going afterwards.
Yep, absolutely.
A couple of questions have come through about the timing. I think my understanding, Frank and Rob, is that all of these laws are up until 31 December.
Yes.
This stage.
Yes, and I suppose the question there from Anna, who's a very long-term client of ours, the obligations in relation to extending residential tenancy agreements only relate to agreements that are ending on or before 30 September 2020. So I suppose that's so if you've got an agreement that expires in October, you don't need to, under this regulations that stands right now, automatically grant people a further extension of that. So that's really covering people whose tenancy agreement might expire on the 31st of July that are suffering excessive hardship. Landlords can't just get rid of them. They've got to extend them through to the 29th of September, which I suppose follows on there. What if the tenants refuse to sign a new lease? To me, I think you're probably really, there doesn't appear to be anything specific there.
It's periodic tenancy, so same terms apply.
Up until that 30th, yeah. And I suppose then you'd be operating on the same sort of 2 months notice rules you'd need now, Rob, in terms of asking people to leave and all that sort of stuff. So, yeah.
Yeah, that's right. I think it's an important point to make, though, that around the non-payment of rent, clearly there's protections there for the tenant. But, you know, in the future, when that tenant goes to apply for another property, they are going to ask their current agent for the rental ledger to give to the new agent. And, you know, late payments or non-payments will show on that ledger. So there is, as Chris says, an incentive for a tenant to do the right thing here and keep, you know, to reach a mutual agreement with the landlord or agent, because you can't just not pay your rent or pay it late and expect that to not follow you. There may be some protections around being blacklisted on the tenancy databases, but of course there's another layer of checks that a future landlord or their agent is going to do.
Yeah. Which I suppose leads us into unpaid rent, which has obviously been, I think, probably the single biggest issue of contention in all of this, hasn't it? And the questions are starting to show there. So I suppose the regulation remains a little bit vague here for me. So where it gets to, I suppose, is that, well, Rob, we spoke about this morning. Do you want to talk about what you're going to do from a practical perspective here, from managing properties?
So our tenants, 3 or 4 days in arrears, our normal process would be to contact them to say, hey, this can't just be about timing of your payments. What's happening? This regulation is now requiring us to not follow the normal process. If we get to day 8, we would normally be issuing notice to remedy the breach if we haven't had a conversation with them. But now the regulations are showing that if we're aware that they've got an issue with COVID-19, or we ought reasonably be aware that they have an issue. Not sure how we do that yet, Frank. You're going to tell us in a minute. But then we have to actually go a step further with a show cause notice, which is another 14 days added to that usual process. And maybe the timings aren't as important, because after a notice to remedy, we still had to follow a notice to leave process. And we know that can't actually end up with an eviction under this legislation. But it has still added another step that practically our property managers now, when they make that first call, will now need to talk to the tenant and say, is your late payment or non-payment because you are COVID affected, and clarify that so we then have a different set of rules that apply.
Yeah, and for me that the threshold. So I think probably I think it'd be bloody dangerous in this environment to issue a notice to remedy breach for non-payment of rent as opposed to a show cause notice. Just in the circumstances where the wording of the regulation is the lessor knows or ought reasonably to know the tenant is or has been suffering excessive hardship. So how do you do that? Obviously, direct communication is one line. If they're not answering phones, if they're not responding to emails, to me, that's probably back to applications for tenancies at the time in terms of evidence of rent, who they were employed by, et cetera, et cetera. Where you've copped emails from, you know, if it's frank.higginson@virgin.com.au, then clearly you know that I'm probably likely to be affected by this at the moment. And Rob, I think you raised that you might have tenants that have been in properties for 12 years and who knows what's happened job-wise. I think from my end, I'd be saying it's probably got to be a bit of an exhaustive process on the part of landlords or their agents to try to run down whether people have been affected. I just don't, again, back to that scorched earth policy, I just don't think it's going to work in this environment. You've got to try to find out whether people have been affected. And then I suppose going through the unpaid rent, if you go through that process, you issue the show cause notice. If the tenant doesn't respond, then you absolutely can roll into the normal notice to remedy breach. If the tenant does respond and say, actually, yes, I have been affected, then there's a requirement to negotiate.
Yeah, that's the tricky part, of course. There's no real clear parameters there, but practically, we all want to get a result here, and I do think there's going to be, and we're already experiencing this. We have quite a number of these situations in our office that have evolved over the last month, and we're getting results through negotiation. Mostly, people have been reasonable.
Yeah, and that, I suppose there's nothing there at all about what happens with, you know, if I'm paying $1,000 a week and I reduce it to 500, what happens with that $500 gap over a period of time? Nothing there about when it might revert or go back up. And so what are you seeing, Rob? Are you seeing anything specific? Are people relenting? Are they trying to back end some of it? Are they discounting it full stop? Or is it
I think
everything?
when the states each first came out with their draft guidelines or changes to this, Queensland and Victoria went to the, no, you can't defer the rent, you must waive it. Where New South Wales and WA quickly said, no, we'll allow the parties to agree, and if they want to defer the payment to later, they can. Queensland's backflipped on that, and these regulations show that you can really negotiate whatever's going to work for you. So, of course, the landlord's preference, our preference as their agent, is to defer or add it to a later time when they get their job back, those payments are coming through and they can afford it. I think the word of caution, though, is that practically not a lot of people, tenants, property owners, all of us included, run at hugely surplus cash flows, and I think you've got to be realistic about how much you're adding on to your tenancy at the end in terms of an unpaid debt. It may be okay to ask it, but I think landlords and agents need to be practical about what really can get repaid at a later date.
Yeah, which ties into one of the questions asked, Rob. Does landlord insurance policy generally cover that non-payment of rent?
Got any insurance experts on the panel?
Well, no, I'm not. I'm definitely not an insurance lawyer. I am not licensed to provide insurance advice, but I can tell you what people have told me is that landlord policies don't actually usually cover negotiated reductions in rent. So they cover default by tenants and damage and people leaving and breaching the tenancy agreement, but not negotiated outcomes. The same as what was really interesting for me from a business perspective, it seems that most business interruption policies don't cover pandemics. They cover physical damage.
Yep.
So not these things. And then I suppose in terms of if we negotiate and get an outcome, great, gets documented and away we go. If we don't, then there's a requirement to conciliate, and that's going to be via the RTA. So I suppose I've never been in that jurisdiction. Have you, Rob?
Yeah, we have, and not regularly, fortunately, because conciliation is is a fairly common process. Keep in mind, only about 4% of tenancies in Queensland end in dispute, so conciliation is not a hugely common thing. But we are told that this is going to be this workload of this mandatory conciliation, if you can't agree, is going to be added to the RTA's workload. We know that already their waiting time is about 2 months, so let's be practical again. It doesn't matter what the legislation says. you're not going to get to conciliation. You need to sort it out yourselves with a good agent in the middle now.
I think that's absolutely right, Robin. And the other point I'd make is that having had a bit of experience in managing a conciliation service, it's nothing to be afraid of. In fact, it can be a really positive experience because conciliation aims to educate parties as well. So you rock up to the conciliation usually, and by all means, it's about negotiating an outcome, but at the same time, the conciliator plays a role in trying to make sure that everybody is on the same page with information and education. It can actually be a very positive experience moving forward.
Mate, I just might close out what happens then if you don't reach agreement at conciliation. You make an application to QCAT. And beyond that, there's no guidance there about what the order might be.
No.
So that would inevitably have to deal with whether we are back-ending the rent. No doubt a landlord would make an application and say, well, I want that $500 a week that I've been missing for 4 months. The tenant will say, I can't afford it. Where it goes from there is not prescriptive in terms of this regulation.
But clearly though, Frank, at that point, from a landlord's perspective, they have placed the tenant into a notice to remedy breach, and as we said, that does appear in their future tenancy records. So, tenants are going to be aware of that.
Absolutely. Question, which I think is a relevant one. Is there any offering of relief for investors? Not under this legislation, there's not. There's some limited assistance that's been floating around in some areas, but I think it's fair to say that the focus at the moment has been on tenants and not landlords. It does, however, raise some interesting points from a body corporate perspective, he says, doing a nice segue. So in a lot of cases, an investor would be an owner of a lot in a body corporate. If your investment is an apartment, for example, that's the obvious example. So as an owner of a lot in a body corporate, you're obliged to pay levies. And then the body corporate can also apply a late penalty, can remove a discount, and can apply interest to your payment of those levies. A body corporate can't waive your levy obligation. There's no capacity to waive that, but what they can do is they can waive some of those charges. There's a legislative requirement for the body corporate to consider special reasons to do that. One of the questions that Frank and I have been dealing with a lot over the past couple of weeks is from body corporate and body corporate managers about, well, how do we assess the basis on which we give a discount or waive those fees? I think this legislation actually is useful in doing that. We now have a definition in legislation of what hardship is. I would be thinking that for committees and body corporate managers, you take this definition in the residential tenancies regulation about hardship and you apply it to an owner, because I think the same thing has to apply. Gents, your thoughts?
Couldn't agree more, mate. It's sort of what's I suppose with lawyers make a lot of their money from arguing over words in legislation. So from a body corporate perspective, acting reasonably is the phrase that gets used all the time. What is that? It's very subjective. I think when Parliament has provided pretty clear guidelines about what means excessive hardship in a financial context, I suppose, of people's financial obligations to pay something, I think it's a very solid base to use that to assess anything else we've got going forward against that. And in a body corporate context, I think it's pretty hard to argue against that. I don't know, you go to the Commission's office at some stage saying, well, they didn't give me a discount because they said that my income's only come down by 40% and it needed to be 50. It's like, well, hang on a minute. This is where they've got to with rent.
I think, look, I agree with both of you. And I think probably to give those running the budgets of Bodies Corp no consolation. We did a webinar with about 100 of our landlords on Monday night, and we did a poll as we were doing the webinar and asked, have they already been impacted personally, their finances? And 54% of them said yes. So we've got some looming issues around late payments or non-payments of levies, that's for sure.
And don't forget that the whole point of a body corporate levy is to pay bills, to keep the body corporate going. It's not as though, for example, that insurance companies are suddenly going to turn around and say, don't worry about paying your body corporate premium. That's not going to happen. Body corporate still has to pay for that. They still have to pay for repairs and maintenance. Levies will still need to be collected. There are ways and means to reduce and amend and how those levies are paid. We're not going to go into that into too much detail today, but at the end of the day, a levy still needs to be paid. I had a question about tenancy databases, which is probably a bit of a relevant question, and it was, has there been any ruling on when ticker or similar can be made for rental debt of COVID? Well, in fact, the regulation covers that. So if you are being exact, section 46 of the draft regulation talks about that. So, so basically, and I'm paraphrasing here, the operator of a tenancy database, be they ticker or whomever, must not list information in the database if the failure to pay rent happened during this current emergency and was because of the person suffering excessive hardship or complying with a public health direction. So again, it's not a blanket catch-all. It's if it happens in this period and you're suffering hardship or you're complying with a health direction and that meant that you were behind, then it means that ticker should not be putting that information onto the database. There are a couple of exceptions listed there. One of those, interestingly, includes that they did not inform them that the failure was because of those circumstances. Rob, anything that
only look, I would note that it's around failure to pay rent. So if that tenant is COVID affected, hardship, but then they go and destroy the property, then there's clearly still an opportunity to list them on ticker. It doesn't go as far as saying it's anything other than failure to pay rent or any in the agreement. So it's not all bets are off. This is about financial hardship.
That's right. And I think there's also, correct me if I'm wrong, on that point, if there was action started from an agent against a tenant before COVID, about non-payment, then it continues, doesn't it?
Yeah, I think, look, I've got personal experience with this where I have a tenanted property that I own where the tenant was well in arrears prior to March 29. Subsequent to March 29, she's lost her job. So pretty confident she's not watching this. I'm going to be very careful about how far I push that, of course, because, you know, I think if it ever got to a tribunal, I'd have a hard time establishing that she could catch up on unpaid rent because she lost a job.
So again, I think all that does is highlight the need to treat each case on its merits. You can't apply a blanket. There are absolutely guidelines and there's now law and we should be applying that, but we have to always take into account specific circumstances. You can't say that every tenant is the same. One tenant situation will always be different from another. Gents, shall we move to the issue of entry to premises and people doing repairs? Because that's an interesting one that has come up a lot in body corporate world, and I suspect, Rob, it's come up a lot in real estate world as well. One of the issues that I've been hearing about a lot from bodies corporate and managers is the idea that you've got work that's either been scheduled in a building or needs to be scheduled, apparently, but to bring a tradie on site to do the work is probably going to mean a breach of social distancing rules.
Well, I guess the practical side of getting that work done, every tradie's had to learn how to work in an environment where they honour that 1.5 metre 4 square metres. I think typically most of us are adapting to that. So maintenance, I think it's interesting that, you know, there is some protections in these regulations for a lessor that can't perform maintenance because their tradie can't attend the site or can't get supplies. They're actually won't allow the tenant to breach the landlord. So that's some good news if that becomes the case. But as far as access to the properties more broadly, as agents, and we're relatively pleased with what the outcome's been.
And I think there's also the ability for the tenant to refuse entry to do work if they're in a situation where they're quarantining or they're vulnerable, under that definition of vulnerability, Frank, that you said before. So
yeah, absolutely.
I think that's as you say, Rob, that's a really good recognition of some of the practicalities of the situation. Important to talk about the fact that there is a slight difference when it comes to body corporate legislation. So here we're talking about a landlord either doing something proactively or responding to a request to do some maintenance. In body corporate world, the body corporate has a responsibility to, first of all, manage common property. And second of all, they also have, would you say, Frank, a obligation to do work if the owner isn't doing it themselves.
Yes.
Yeah. And same with the tenant. So this goes back to my point earlier about tenants having rights and obligations under body corporate legislation. There is a provision of the body corporate legislation which puts an onus on an occupier, which is the word used for a tenant, to maintain their lot in a clean and tidy condition. So if feasibly, if the tenant is not doing that, the body corporate can actually move to a position where they can do it themselves. And not only that, the body corporate has power under legislation to enter the lot, don't they, Frank?
Yeah, absolutely. After giving 7 days notice, yeah. So it's sort of, and I suppose this is an example of what the normal process might have captured in terms of introduction of legislation on short notice, where probably there would have been some attempt to make those rights a little bit more parallel. But at this point in time, there's nothing there about bodies corporates at all. Obviously, this is the Residential Tenancies and Room and Accommodation Act, which really doesn't mention body corporate in any way, shape or form. So BCCM Act obligations still sit there on their own, and body corporate rights in that sense or obligations haven't been affected at this stage. And I think if we come back up a level to the Act itself with the ability of the Minister to make what they call extraordinary regulations relating to certain things, those things might be addressed at some stage, who knows? And I know probably one of the interesting things in that Act for me was they basically got the ability, or he's got the ability to make regulations relating to obligations for people attending things. So that opens the door for body corporate meetings at the moment, which really can't be conducted in this style of format, to basically be created without reference to Parliament for the time being.
Yeah. So what I mean, it's for example, and this might be relevant for a lot of tenants who are tuning in today. A body corporate does have the power to enter a lot without permission. But now it's under fairly extreme circumstances, emergency circumstances to be precise. But they do have that ability. Not only that, the body corporate can seek a penalty to apply on somebody who obstructs that situation. So that's a bit of a disconnect there. On the one hand, you've got these new laws, which are talking about a tenant's rights to refuse entry if under particular situations. On the other hand, the body corporate can enter, and there can be a penalty if the body corporate is obstructed in entry under those particular circumstances. Again, what it highlights is the need to communicate early and communicate clearly. So if the body corporate knows there's a problem, get in touch with the landlord, get in touch with the tenant, get the lines of communication open, but also explain the reason why. You don't just enter for the hell of it. You enter with a defined reason and and particularly if it's urgent, you must demonstrate why it is urgent.
There's a really interesting new question there for Rob that actually is interesting for me too. What are you doing for filling vacancies now, new tenants and that sort of stuff?
Oh, look, that's, I apologise, I can't see the questions on my screen, but look,
so the question is just simply, can Rob give advice on how he's approaching new tenancies?
Well, the good news, not great news, but the good news is we're still getting tenant inquiry. And in fact, we're letting properties. So our agency is in Brisbane. I can tell you in the last 7 days, we've had 123 new tenant inquiries come in the door. So the wheels are still turning in terms of letting a property, and even some of those that are coming out of short stay and been added to the long-term pool that we have, they are being let. Rents are being adjusted, which is no surprise. But not wholesale discounts yet. So we're letting property. There are tenants to be found.
Can I ask you a very random question on that topic, Rob?
Sure.
Do you or any of your team ask people anything about COVID? Do they ask questions, for example, about where they've travelled or diagnosis?
Yeah, part of our, before we take someone to a property is we're checking in on their health. So yes, we've introduced we've been doing virtual tours on rental properties for over a year, but we've now introduced video walkthroughs as well. So hopefully by the time someone says, yeah, I like that place, they're fairly well qualified. And of course, we're not doing open houses. That all stopped a month or so ago. But yeah, before we actually attend that private viewing, the one-on-one, we are checking in on their health. So clearly they're not returning fresh from overseas now. The borders are closed, but that was an issue for us. So we've had to be pretty careful with that one.
Because I asked Rob, because that's been a question Frank and I have confronted many times lately from on-site managers in particular, who have been asking the question, can I ask somebody if they've been diagnosed, or if I suspect that somebody has been diagnosed with COVID, can I or should I be telling the rest of the residents in the building? And what Frank and I have been saying is you've got no power to ask that information. You can certainly ask it, but again, it depends what you do with the information after that.
Yeah,
it's pretty intrusive.
Well, it's part of our workplace. When we go to do an inspection, that's their home becomes part of our workplace. So we believe we're entitled to know what's going on in the home. And of course, we've had very early on through our normal routine inspections, we had a tenant respond to our entry notice to say, look, you can't come in. I've just returned from overseas and I've been diagnosed. So we moved to routine inspections virtually over a month ago now with our tenants' cooperation, and clearly under the new legislation, the regulations are going to require a tenant to cooperate with that in the future. So that the world's changed, and I think people are generally okay having those conversations. But as to a caretaker asking all residents in a building, yeah, I'd agree. How is it relevant to them unless they're actually needing to enter the property?
Thanks, Rob. I might, if it's okay with you two, I might turn to the sometimes very vexing issue of locks. It's a bit of a random one, but...
And probably, I think it's probably worth saying that the regulation they introduced last night includes more than just issues relating to rental law reform in terms of rent, because there was a policy paper out early this year. I don't know, I'm losing track of days of the week, let alone months of the year, November, which is all about rental law reform, and they have built some of those into this regulation. So Christopher, back to you on locks, because this is one of them.
So if a tenant believes that they need to change a lock due to domestic violence, they can do that. So effectively, these laws now give effect to a situation where somebody is in a domestic violence situation and needs to protect themselves, and one of the ways they do that is to change the lock. They can do that. They must give the lessor a key. There are some grounds on which that needs to happen. There's a few grounds on which that needs to happen. I don't think anybody can argue with the idea that there's a need to change a lock in a domestic violence situation. So none of that is in dispute. The interesting point it does raise, though, is the issue of a lock itself, because when we talk about locks, keys and fobs, particularly, again, in a body corporate situation in a high-rise building, it's actually not very clear who is responsible for the maintenance of a lock. So the general rule of thumb is if the door is in a boundary wall between the lot and the common property, the maintenance of the lock would usually be the body corporate's responsibility, and an owner, or indeed an occupier, would usually need body corporate approval to change it. So important to remember that. This goes back to my point again earlier about an occupier or a tenant has a responsibility on body corporate, under body corporate legislation. The new laws passed last night make it clear that that changing of the lock needs to be subject to body corporate bylaws, which is fine. But if a body corporate is already responsible for maintenance of a lock, the bylaw isn't necessarily going to be applicable. So this might be a situation where there's a bit of inconsistency between the two sets of laws. Frank?
Mate, simple as that. Absolutely. Bylaws don't deal with locks. That's a statutory thing. So again, I suppose you'd say that's a slight little miss from a government perspective, understandable in the circumstances. But yeah, that doesn't really cover it. So we're going to have, well, again, the domestic violence components people changing locks without reference to bodies corporates, and who knows what comes from that.
Yeah.
I think there is an obligation, or at least there was in the draft that we saw last November, that the keys be provided to the managing agent or lessor within reasonable time. So,
and that's still there, definitely.
Yeah, you'd hope that can also then be provided to the on-site management where appropriate.
Yeah. I might go to a few questions that have come through, and we might try and knock over in the time remaining those and anything else that pops up. I'll go right back to a couple that I missed earlier. Here's an interesting one. If the rent is if a reduced rent is agreed upon, can the rent be raised again after this period?
My understanding is yes.
Yes, absolutely. Yep.
Yeah.
Absolutely. So I think there's.
Sorry, go on,
Sorry,
Frank.
Rob. I was going to say, it seems that there's prohibitions on under the existing RTRAA in terms of increasing rent. I think no more than it's 2 months before the expiration of a tenancy. I think they've relaxed those rules in a sense that if you discount the rent now, it can go back up without the need to give that 2 months notice and all that sort of thing, I suppose, when we're through this period, but only on the condition it's not more than what was paid previous.
That's correct.
So again, yeah, $1,000 a week now. We're down to 800 for the next 8 weeks while we get through this. You can kick it back up to $1,000 a week without having to give the required notice. But if you went to 1,005, you wouldn't be complying with that provision of the regulation.
I think it's worth noting that the draft legislation or reforms that we saw in November, tabled by the Minister, they've intended to legislate prior to the October election. We don't know what's going to happen now, given all these changes. But phase 2 of that, which was openly talked about, was that there may be some reforms that included conversation around limitations on rent increases. So we don't have any detail around that yet, but that consultation paper in November it said at the top of it, stage 1. And stage 2, we are told, is highly likely to include rent controls.
Okay, it's good to know, Rob. Yeah. Another question, this is a body corporate one. Can an AGM or an EGM vote to cease payments temporarily to the sinking fund? The short answer is yes. The longer answer is it's a process of adjusting your budget at one of those meetings and also taking into account what the body corporate actually needs to do. Frank?
Absolutely. So, yeah, so it's funny, not funny. Administrative funds are fairly finite. Body corporates have got to spend, 50 grand on insurance, 50 grand on a caretaker, roughly 10 grand on repair and maintenance, 20 grand on your strata manager, whatever it might be. Those are fixed costs year in, year out, no matter what. So in theory, your admin fund should zero out at the end of the year. Sinking fund, every body corporate's required to have a sinking fund forecast, but the quality of that is obviously wide and varied. There's a range of experts that do them in the full-blown report. And in theory, there's no reason you can't sit at the pub with the treasurer and do one on the back of a beer coaster, and it still qualifies. So I think probably what we will be seeing is some sinking fund budgets get adjusted in terms of what's needed to be spent, or what may have been on the agenda to be spent next year to be spent in 2024 instead, and therefore the liability for those particular amounts slowing down in the short term. And we sent a piece of content earlier this week about adjusting budgets that I think it's important to be aware that just kicking the can down the road for 6 or 12 months doesn't necessarily help. And I suppose, Rob, subject to where, the great crystal ball about where the property market goes in all of these circumstances, and obviously in terms of selling real estate in due course, if we're looking to sell units in bodies corporates, high rise or otherwise, if places are poorly presented because we've stopped raising money and stopped investing in sinking funds, that's probably might save you a little bit in the short term in terms of the weekly cost, but might cost you more in the long run in terms of loss of capital value or inability to attract the right buyer. So
cut off nose to spite face. Yeah.
Yes, penny wise, pound foolish.
I think there's more awareness the last few years from buyers about sinking fund balances and what that means. They're slowly starting to educate themselves around the risks in buying in. If the fees seem too cheap, there's probably a reason.
Yeah.
Well said. Couple of quick questions.
Actually, that last one's really interesting there. Loss of income from employers. I suppose from my end, an easy way to do that would be to look at JobKeeper. So JobKeeper is, you need a 30% loss in revenue and you qualify for that. So from a business perspective, assuming that most tenants are in less than $1 billion turnover territory, which they probably will be, that's probably a very interesting, so an immediate question, if a self-employed person qualifies for JobKeeper, I think it, so me, I'm run my own business. I think probably that's an example that may get across that line straight away. But obviously, question again, what's the evidence? It's a reasonable thing to ask. It is. Yeah, there's no hard and fast rules. Yep.
Back to a ticker related question, and the next one was, if the rent relief has been agreed upon and then that's not adhered to, can that breach be listed on ticker? My take on that would be yes. Rob?
Well, the wording of that section is around you can't list them on ticker if it's the failure to pay rent or the ending of the agreement happened during the emergency period. So actually, I don't know. It seems pretty broad to me.
That's a tough one, because to me, I'd take the view that if you agreed on a rent reduction and signed off on that, from the tenant's point of view, you were doing so because that's what you were capable of paying. So then if they still didn't pay, I think the first step would be to ask the question, what's happened? It may well be that there's been a change in circumstances which has made their financial position even worse than it first was, in which case you might have to renegotiate again. But how you tell that, that's a really tricky one, isn't it?
Does it reset? Does excessive hardship reset? As I sit there and look at it. So today, this is the position. I think in 6 weeks' time, I'll be back at work because pubs and clubs should be open. And then in 6 weeks' time, it's not. Do you go again and say, well, is it now 25% less? Because I cut that deal at that time thinking that was going to be the position. It turns out, if it hasn't changed, or maybe it has, yeah, these are some of the things that I suppose the minister at some stage may need to provide some more directional guidelines around, because they're legitimate questions.
I can tell you, look, in the draft legislative changes we saw late last year, all of the provisions around the tenancy databases are getting watered down even further than they were a few years ago. Tenants unions hate the databases.
Yep.
There's a lot of, this government is very receptive to their voice, and I think you'd have to reasonably expect that there's going to be more limitations. I can tell you practically that agencies have for some years now not relied on TICA and other databases. We do rely more and more on those tenancy ledgers, those questions to the past agent around whether they issued notices to remedy, whether they ever issued notices to breach, notices to leave. They're the things we look at. TICA is important. Those databases have value still, but not of the same value they used to have.
Yeah, fair point. I'm going to finish with one of mine and Frank's, and I dare say yours, Rob's, favourite questions. Smoking. When is there likely to be some regulation regarding tenants and smoking on balconies and bodies corporate? It's particularly important while people are isolating. Good question. I think there's an emerging body of research which creates a very strong link between smoking and COVID. I'm pretty sure I have read that information somewhere, and it makes sense when you think about it because it's a respiratory ailment.
I see where you're going with this. Yes.
But in answer to that very specific question, so just to clarify, the government pushed the issue of smoking in bodies corporate on the agenda and has had that issue on the agenda for some years. Has any position been taken on it? No. There's been no change to the law. The basic rule of thumb at the moment is that the body corporate can pass bylaws to regulate smoking on common property, but when it comes to a person's individual lot, and a balcony is usually part of their lot, there's not really any ability for the body corporate to regulate or indeed prohibit that. Frank?
Agree. And I think I remember doing a seminar many years ago when you were the commissioner, Chris, and it's sort of at the end of the day, smoking's legal.
Yep.
That's the reality of it. So, and how you regulate a nebulous substance that sort of drifts, and it's a little bit like you know, the reality is that a lot of our body corporate disputes are human behaviour style issues. You're never ever going to be able to legislate that. So, but yeah, maybe there is a bit of a angle to play here from a smoking perspective in the long run. Who knows?
Just a couple of quick things. Nikki, thank you. Nikki tells us that there's a fact sheet on the LookUpStrata site, and it is their most viewed fact sheet across the country. Surprise, surprise. Very, very quickly, a question about cigarette butts. That's a slightly different issue. That might be dealt with under nuisance provisions. You might like to speak to a recognised strata law firm about that particular issue.
Well, David knows where he can find me, so.
That is all we've got time for today. We could probably keep talking about this for quite some time, I reckon, but that's all we've got time for today. I want to say thanks to everyone who tuned in. There are a lot of webinars floating around at the moment, so the fact that you would choose to spend time with ours, really appreciate it. Thanks to Nikki and Liza at LookUpStrata for organising and putting this together. And Rob and Frank, it's been a blast.
Absolutely. Thanks, Chris.
Thank you.
You're welcome.
See you at the next one, everyone.
Done. Okay, see you.
Cheers.